Twitter is now reciprocating Elon Musk's favour by requesting information that he does not want to be made public. According to the business, Elon Musk was unwilling to exchange evidence before the trial in the dispute over his $44 billion buyout offer, so the company decided to request the Delaware court judge to order Musk to provide all of his text messages from his phone for 6 months, and the judge's response was very interesting. With that, recently there have been various shocking revelations about this lawsuit, about possible harassment cases, unethical behaviours, and unfair practices that Elon Musk and Twitter are dealing with. This is a mind-boggling development of this story, so let's explain it. The social media business filed the sealed petition for sanctions against Musk and his attorneys in Delaware, along with the public proposed order. According to court filings, the business is requesting that Delaware Chancery Judge Kathleen St. J. McCormack should force Musk to turn over all of his text communications from January the 1st through July 8th. Twitter also requested communications from Jared Birchall, a key Musk ally, for the same timeframe. Birchall, who manages Musk's family office, is believed to have played a significant role in organising the finance for the acquisition of Twitter. When it came to providing the messages during the pre-trial in the suit compelling Musk to complete the $54.20 per share purchase, Twitter's lawyers claim Musk and his lawyers did not behave in good faith. More than 100 banks, hedge firms, and people have been subpoenaed by the platform and Musk in preparation for the Wilmington, Delaware trial. The defense team for Musk denied any impropriety about the sharing of information before the trial. According to them, Twitter had attempted to conceal witnesses who had data on the quality of spam and robot accounts present among the platform's users. Questions regarding the spam accounts have been the focal point of Musk's justifications for abandoning the agreement. According to one of Musk's attorneys, Alex Spiro, Twitter is now attempting to divert attention from this nonsense since its efforts to conceal facts and witnesses have fallen apart. Twitter also requests that McCormack order Musk deposes on his legal team's replies to Twitter's inquiries over the deal, according to the proposed order. The court has also determined that a friend of Elon Musk, who was subpoenaed in the Twitter takeover litigation, has lost an appeal to have the request quashed due to his conduct on Twitter and his podcast. According to court filings from Chancellor Kathleen McCormack, David Sachs, the CEO of Kraft Ventures and a member of the PayPal Mafia, had his appeal dismissed after Twitter subpoenaed him for communications with Musk. Sachs claimed on his All In podcast that the social media site had subpoenaed him because of his remarks on the Twitter purchase, which he claimed were highly generalized. Despite the former PayPal executive's protestations that he was involved in the acquisition, he was nevertheless served with the widest subpoena ever. He had to hire a lawyer to get it quashed since it was 30 pages long. Due to Musk's withdrawal from the $44 billion purchase of Twitter, and his claim that he had been deceived by the number of false accounts on the network, the two parties have filed countersuits against one another. During the thick of his takeover attempt in May, Musk made an appearance on Sachs's show. One of Sachs's tweets that led to his subpoena was believed to be a list of issues Musk would need to take care of if and when he took over Twitter. According to the petition, Sachs, a well-known venture investor, had signed a non-disclosure agreement to assess a prospective investment in conjunction with Musk's purchase of Twitter. The Delaware subpoenas from Twitter, according to Sachs' attorneys, were improper because they duplicated the California subpoenas, imposed an excessive hardship, and had too soon of a return deadline. Sachs also complained about needing to retain attorneys. Twitter complained about this conduct, and McCormack cited it as the basis the subpoena couldn't be revoked. She also said that Sachs's complaint about the necessity for attorneys was pointless and only seemed to have taken place because Sachs promised his podcast listeners he would. The movers established the same burden about which they complained in an obvious effort to uphold Sachs's commitment to his podcast listeners. The decision by McCormack may have repercussions for prolific tweeter Musk, who has frequently used the site to criticize Twitter. Professor at law at Columbia University, Eric Talley, said that she would likely weigh negative tweets while making her decision. In response to Sachs's allegations that the business was harassing him, Twitter snapped back. The investor, who has assisted Musk in starting PayPal and is one of the entrepreneurs who received subpoenas for his firms, Kraft Ventures Management and Saks.com, is pleading with a Delaware judge presiding over Twitter's case against Musk to throw out the subpoenas. Twitter criticized the investor's response to Sachs' move to revoke the subpoenas as vulgar and swift and obscene, referring to tweets he sent about the social media platform that featured a picture of a middle finger and a video of a guy peeing on a subpoena. According to Twitter, the request to revoke the subpoenas appears to be made only to fulfill Sachs's wish to flip Twitter the bird. According to a filing, the investor agreed with Twitter's legal demand for information on his firm's awareness of Musk's decision to back out of the purchase. Twitter, however, criticised his answer as being delayed, secretive, and incomplete compliance, and sent subpoenas to both of his Delaware and California firms. The social media firm said Sachs misled the public in a podcast and Bloomberg television appearance in which he repeatedly claimed he was completely unconnected to Musk's ambitions to acquire Twitter or eventually try to back out of the transaction. While we are on that topic, the billionaire Elon Musk's legal difficulties are the focus of a new program at the UCLA Law School. The program will be presented next semester, with Tesla and SpaceX engaged in lawsuits surrounding the CEO's salary, the prospective Twitter purchase, and associated securities inquiries. The Law of Elon Musk course, taught by corporate law specialist Professor Stephen Bainbridge, discusses Musk's push-the-envelope style of corporate leadership. Bainbridge also discusses the lawsuits involving Tesla's acquisition of SolarCity, a company in which Musk was a shareholder, the ongoing legal dispute regarding Musk's proposed acquisition of Twitter, and possible conflicts of interest in his business affairs. According to the course synopsis, Musk is sometimes tempted to put his personal interests and aims ahead of those of the individuals who may have entrusted him with their funds because he is in charge of handling a sizable quantity of other people's money. This course looks at some of the ways that the law limits, or does not limit, Elon Musk's deviations from shareholder interests. Musk, according to Bainbridge, is a very intelligent and daring individual who is capable of coming up with ideas that produce great levels of revenue, but who could be difficult to work with as a client since he frequently leaps before he looks. These jumps, he claimed, have led to a pattern of ongoing legal procedural misconduct that has given rise to numerous cases and securities litigation. Well, that's it for today. Don't forget to subscribe.